One of the things that happens at arraignment is that the clerk will read the charges against the defendant. So a number of things will happen, but this is usually one of the first things. The defendant will be called forward. The clerk will recite the title of the case, Commonwealth v. whoever it is, will read the docket number, and then will read aloud to the open court the charges against the defendant. So of course, this could be extremely embarrassing for the defendant. Defendants who are represented by an attorney can ask that the reading of the charges be waived. So typically the way this will be done is the docket number will be read, and then the lawyer will say, we will waive the reading of the charges. In some cases, the clerk will just do it automatically if it's a very busy courtroom. But in most cases, the lawyer needs to ask, and this will hopefully spare the client or the defendant some embarrassment, like I said. Now, the prosecution, there's really nothing you can do if the prosecution wants to speak and not just state the charges, but basically read the police report. This most often is done when the prosecution is asking for bail. So if there's going to be a bail argument, and if there's a serious offense, or if you have a history of offenses or of not appearing at court, the prosecution can ask for bail, and almost certainly the prosecution is going to read the police report or summarize it at least. So even if the charges are waived, it doesn't help you much. All right? But if you're going to court for the first time and you're nervous and you're embarrassed and whatnot, one of the things, like I said, if it's a minor offense, you could simply have the court waive the reading of the charges, and then you could just spare yourself at least that one portion of the arraignment. If you have questions, send me an email, or if you have thoughts, please leave comments below.